Good morning, everybody. Thank you for joining me for today's webinar. My name is Amber Hines, and I'm the owner of Ashbur. Today, we're going to be talking about how to deal with previous gifts in a married couple situation. If you have any questions during today's presentation, feel free to type those into the questions tab of the GoToWebinar dashboard. And also, if you're interested in a copy of the handouts of today's slides, you can find those in the GoToWebinar dashboard as well under the handout portion. Again, my name is Amber Hines. I'm the owner of Ashbur, and we specialize in helping advisors and attorneys with pre-planning solutions as well as crisis Medicaid planning solutions. I have been working with elder law and estate planning attorneys for the last 15 years on Medicaid compliant annuities. I'm insurance licensed in all states, and I also hold my Series 65 license with FINRA as well. If you currently are working in the Medicaid crisis space and you have questions related to a potential case, feel free to reach out to us. We do offer complimentary case analysis, which would take into consideration the topic that we're talking about today about previous gifting when we are dealing with both married couples as well as individual clients. We offer complimentary case analysis, which will help you to determine the optimal amount to purchase an annuity for, the term of the annuity that may be considered, and which assets you may consider annuitizing for a client, especially if your clients have existing IRAs or annuities that are going to be considered countable for Medicaid qualification purposes. We can help you to determine whether it makes sense to do a 1035 exchange or a direct transfer of those accounts directly into a Medicaid compliant annuity. We offer assistance from the beginning to the end of a case. And so if you have questions about the term of the annuity or how much the annuity should be purchased for, we will help to provide quotes and also assist with the actual funding of the annuity. That can be a pretty simple process if it's money that's coming just from a checking or savings account, but it can be a little bit more convoluted if we're talking about transferring multiple retirement accounts or existing annuities into a Medicaid compliant contract. And then also we do assist with the death claim process if that does become necessary. If you have a client that purchases an annuity from us and they pass away during the term of the annuity, we will help to reach out to the state Medicaid agency, determine if there's any claim that the state has, and then assist the secondary beneficiaries to be paid out the remaining annuity amount. We work with A-rated insurance carriers, so your clients don't need to be concerned about the rating of the insurance company when you're working with our company. And we offer top-notch customer service. So we get back to all the law firms and the advisors that we work with within 24 hours with a proposal and answer the questions that they have related to purchasing an annuity. When we're talking about Medicaid crisis planning in general, the planning goals that we're trying to achieve for a client that is in Medicaid crisis mode or looking to qualify for Medicaid pretty immediately is we're looking to convert what Medicaid considers to be countable assets or countable resources into non-countable or exempt resources. And we want to do that in the most cost-effective, tax-efficient way. So if we have clients that have large retirement accounts or existing annuities that are going to have pretty substantial tax consequences associated to converting those accounts into non-countable assets, we may want to consider whether it makes sense from a longevity standpoint to do that type of planning. So those would be things that we would take into consideration when we're looking at a client situation. What type of assets they have, are they countable, and how can we make them into non-countable assets so that they can qualify for Medicaid as quickly as possible. The second goal is to obviously obtain Medicaid eligibility as quickly as possible without any private pay or penalty period associated to doing a Medicaid plan. And then finally, the last goal is to minimize or avoid estate recovery if we can do that. When we're talking about a married couple, there are both income limitations as well as asset limitations. For the income limitation with a married couple, the institutionalized spouse or the spouse that is applying for Medicaid, their total income must be less than their cost of care, with the exception of states that have an income cap. The current income cap in most states is around $2,500 per month. If you have a Medicaid applicant that has more income than the $2,523 per month, then a qualified income trust or a Miller trust would need to be established to have the excess income go into the QIT in order to establish that the Medicaid applicant is below the income cap in that state. When we are talking about a community spouse or the spouse that is at home, they are entitled to an unlimited amount of income, and they, in most states other than New York and Illinois, they do not need to contribute any of their income to the Medicaid applicant's cost of care. So they can have as much income that's being generated as they wish by way of an annuity. We obviously want to keep that income reasonable based on what the cost of care would be, but the community spouse does not have an income limitation. When we talk about the asset limitation for a married couple, the Medicaid applicant or the institutionalized spouse usually is able to keep around $2,000 or less of liquid assets. This does vary depending on the state that you're in. Some states like Missouri is around $5,000. Pennsylvania is a little bit different with the amount that they're able to keep as well. But the most common number is around $2,000 that the Medicaid applicant can keep. A community spouse is able to keep around 1/2 of the countable assets up to a maximum of $137,400. And again, this does vary depending on the state. A state like Illinois is still stuck with a number of around 109,000 that they're able to keep. So if you have questions about how much assets a married couple is able to keep, you can refer to our website or reach out to us with any questions related to that. Other resources that are considered to be exempt or non-countable for Medicaid qualification purposes include a home, an automobile, household goods and personal property, an irrevocable funeral trust or prepaid burial policy. And then some states do consider IRAs to be a non-countable asset as well. And in some states, this depends on whether it's an IRA that is owned by the Medicaid applicant versus an IRA that is owned by the well spouse. Most states do consider IRAs to be countable, but there are some of them that do not count the IRA in the qualification process. If your Medicaid clients do have excess assets, we generally are going to develop a Medicaid eligibility plan. And this can include increasing or improving non-countable assets, making home improvements, purchasing a new car, purchasing prepaid burial policies, paying off credit cards, mortgages, or other debt that the couple has. And then if after all of these items are exhausted by spending down the couple's excess assets, we can consider purchasing a Medicaid compliant annuity that complies with the Deficit Reduction Act of 2005. And if you're looking for an annuity that has all of the qualifying language in the contract that is going to comply with the DRA, it must be an immediate annuity that is in payout status that has all of the items that you're seeing or the language that you're seeing on the screen. So it must be completely irrevocable in all regards. So we can't change any aspect of the contract. We can't change the payee, the beneficiary, the payment amount, or the payment structure. So the contract must be completely irrevocable. Also, the annuity must be non-assignable, meaning that we can't assign the annuity to a company like J.G. Wentworth or Peachtree that purchases immediate annuities or structured settlements on the secondary market. The actuarially sound requirement means that the annuity must be structured with a payment term that is going to return the full initial premium to the client within their Medicaid life expectancy. So we can structure the annuity so that it's shorter than the life expectancy of the annuitant, but it cannot be longer than the life expectancy of the person that is purchasing the annuity. Also, the annuity must make equal payments and not have any balloon or large payments at the end. And finally, the state must be named as a remainder beneficiary on the annuity to the extent that Medicaid benefits are provided. There's an asterisk there because there are some exceptions to the state being named as the beneficiary. Some states do allow for the Medicaid applicant to be named as a primary beneficiary, and then all states do allow for a minor or a disabled child to be listed as a beneficiary before the state Medicaid agency as well. First, we're going to consider a case study that does not have any gifting involved. So this is going to be a married couple situation where we have no gifting that has occurred and one spouse is currently in a nursing home. The other spouse is remaining in the community or remaining in the family home. The goal in most married couple situations is to obtain immediate Medicaid eligibility without any kind of private pay period for the Medicaid applicant or for the institutionalized spouse. And we're going to achieve that by converting excess resources into an income stream. We also want to be aware of what the community spouse's income need is so that we're able to provide them with peace of mind as well as sufficient income and resources so that they're able to maintain their lifestyle remaining in the community so that they don't become impoverished and they're able to still maintain their lifestyle while the spouse that is in the facility is going to qualify for Medicaid. In our married couple situation, we have Roger and Nancy. Roger is an 80-year-old male who has dementia. He has been in a nursing home since September 1st of 2022. He has monthly income of $2,000 per month, and his current nursing home bill is around $10,000 per month. Nancy is 75 years of age. She is the community spouse. She's remaining in the family home, and she has monthly income of $1,000 per month. The couple together has a home, a car, and $400,000 of non-IRA bank accounts. So we're not talking about any kind of retirement or pre-tax accounts. This is all going to be assuming that we're talking about money that's in checking or savings, CDs, things of that nature. And then Roger and Nancy plan to apply for Medicaid as of October 1st of this year. First, we need to calculate the spend down amount. If we consider that Roger, as the Medicaid applicant, is able to keep his personal property, a prepaid funeral policy, and $2,000 of the $400,000 in cash assets, Nancy, as the community spouse, is going to be able to keep the home, the car, a prepaid funeral policy, her personal property, and then $137,400 of the $400,000 in cash assets. This is currently the maximum amount in most states that the community spouse is able to keep. So when we consider the $2,000 that Roger can keep, along with the $137,400 that Nancy can keep, their total protected or excluded assets are $139,400. And when we deduct that from the $400,000 in cash assets, they have too much money of $260,600, or this can be referred to as their spend down amount. the amount that we have to convert into non-countable assets in order for Roger to secure Medicaid eligibility. We can eliminate the excess resources by doing any of the spend down that we talked about previously. They can make home improvements, they can purchase a new car, purchase prepaid burial policies, things of that nature. And then if they've done all of that and they still have money that needs to be spent down, they can consider purchasing a Medicaid compliant annuity for Nancy. Nancy is going to be the annuity owner, the annuitant, and the payee on the annuity policy. We would be looking at putting the $260,600 into the annuity. With Nancy being 75 years of age, her remaining life expectancy is just over 13 years or 157 months. This is going to be the longest time frame that we can do on the annuity, is her Medicaid life expectancy of 157 months. We did shorten the term in this case to 60 months so that we can get the money back to Nancy in a quicker fashion and also increase the amount of income that is being generated under the annuity policy. If we do the annuity for 60 months instead of her full life expectancy, the annuity is going to provide monthly income of $4,500 per month, and the total payout of $270,000 is representing the original investment of $260,600 plus some interest that would be paid on the annuity policy over the 60-month time frame. When we look at how the annuity affects their monthly income, we first have to calculate Nancy's monthly income because she's going to be the annuity owner and the payee of the contract. So she initially had Social Security income of $1,000. When we add in the annuity payment of $4,500, she has total income of $5,500 per month. When we compare what Nancy's monthly income is at $5,500 to her monthly maintenance needs allowance of $3,435 per month, she does not have a shortfall. Therefore, she's not going to receive any of Roger's monthly income because she has sufficient income to meet what her MIMNA is. So Roger's copay to the nursing home is going to equal his Social Security income at $2,000 less his personal needs allowance of $50, so that his copay to the facility each month is going to be $1,950 per month. You'll notice that there's no shifting of income over to Nancy in this case because she has sufficient income on her own that we're not going to get that shifting of income from Roger over to Nancy. The economic results of the 5-year annuity plan is that Roger and Nancy were expected to pay around $10,000 per month for Roger's care. We were able to reduce his copay down to $1,950 so that the couple experienced a monthly savings of $8,050 per month, and Roger was immediately eligible for Medicaid as of October 1st. The advantages of the annuity plan is that we were able to obtain immediate Medicaid eligibility for Roger without any kind of private pay or penalty period. And then also we created sufficient monthly income for Nancy by shortening the annuity to a 5-year time frame, by shortening the annuity term so that she was able to continue living comfortably in the community and living in the family home. The annuity is not going to cause a penalty period or a private pay period or transfer for less than fair market value because it has all of the Medicaid qualifying language, the items that we talked about initially with it having irrevocable, non-assignable, actuarially sound, equal payments, and naming the state Medicaid agency as a remainder beneficiary. And so the annuity purchase was deemed to be a compensated transfer that is not going to trigger any kind of penalty period or private pay period. The potential disadvantages of the plan is that with the state Medicaid agency being the primary beneficiary, to the extent that Medicaid benefits are provided on behalf of Roger, if Nancy as the annuity owner and annuitant of the 5-year annuity does predecease the term of the annuity contract, the state would be entitled to claim an amount that they have provided on behalf of Roger. And so that was one of the reasons why we reduced the annuity term in this case to 60 months. We could reduce that even more to something shorter than 60 months. But again, we want to keep the amount of income that's being generated under the annuity reasonable in comparison to the potential cost of care in that state. If we consider a fact change now and we consider a situation where we have previous gifting, we'll look at how that's going to affect the plan that we just talked about by purchasing the Medicaid compliant annuity. We'll assume that when you're reviewing the client's financial statements, you discover that Roger and Nancy have made transfers, which are possible gifts of $20,000 over the last 5 years. So first we need to determine if the transfers will be treated as gifts or treated as a penalized transfer. If we consider the difference between what Medicaid considers to be a gift and what they consider to be a compensated transfer, a gift is going to be a transfer of assets for less than fair market value or an uncompensated transfer, and a gift made during the look back period results in a penalty period or a private pay period for the Medicaid applicant. This is going to be an example of this would be if the couple gave their child $20,000 to pay off credit card debt, or gave their child $20,000 to just as a gift where the parent was not receiving anything in return for the $20,000 gift or transfer. A compensated transfer is going to be a transfer of assets by a Medicaid applicant for which the applicant received fair market value. A compensated transfer does not result in a penalty period or in a private pay period. So a compensated transfer would be an example of a parent selling their car to their child for fair market value. The parent receives fair market value in return for the sale of their vehicle to a child. The look back period is the period of time that Medicaid can examine an applicant's finances to determine whether an uncompensated transfer has been made. In all states other than California that have adopted the Deficit Reduction Act of 2005 currently have a 60-month or 5-year look back period. So only gifts that are made during the look back period are counted and reported to Medicaid. If you have a client that has made gifts or transfers 61 months prior to them coming into your office, then you would not have to consider those gifts or transfers in the Medicaid application, because that's going to be outside of the 5-year look back period for gifting purposes. Not all transfers will be penalized. Transfers that are made for purposes other than qualifying for Medicaid, some examples can include a consistent pattern of giving to a place of worship or to a church, gifts that are made well in advance of an individual needing care, or if there are nominal or small gift amounts. So most states have a certain amount that they will not consider to be penalized amounts. The most common amount is around $500 or $1,200 that are not going to be considered penalized or not taken into consideration when we're looking at a client's finances. But this exception of transfers that are made for purposes other than qualifying for Medicaid, this can be difficult to prove, and it's not necessarily a slam dunk that the Medicaid office is not going to penalize transfers, even if you can prove that it was a consistent pattern of giving, or if it was made well in advance of the person needing to qualify for care. So you can try and use this as an exception to transfers that have been made, but it's not necessarily going to work as far as Medicaid not penalizing those transfers. If the $20,000 are not penalized and the annuity is purchased like we originally talked about, Roger will be eligible for Medicaid as of October 1st of this year. However, if we're unsuccessful in proving that the $20,000 gifts were made for purposes other than qualifying for Medicaid, then we would need to calculate what the penalty period or the private pay period is going to be resulting from the $20,000 transfers. If we want to calculate the penalty period, we need to look at the total amount that has been gifted within the last 5 years and then divide that by your state's divestment penalty divisor. And that is going to tell us what the penalty period or the private pay period is. So the number of months that a Medicaid applicant is ineligible for Medicaid resulting from an uncompensated transfer or gift that is made during the look back period. So if we're looking at what the divestment penalty divisor is, this is what Medicaid considers to be the average of 1 month's cost of nursing home in your state. A state like Pennsylvania has a divisor currently of around $14,700, whereas a state like Arkansas has a divisor of $7,151 per month. So depending on where you live in the country and where you practice, the divisor amount is going to determine how long a penalty period is associated to making gifts. In this case, we'll consider that, or we'll assume that Roger resides in Pennsylvania and he plans to apply for Medicaid eligibility starting October 1st, with Roger making previous gifts of $20,000 and Pennsylvania's divisor currently being $14,676. The penalty period or the private pay period is going to be 1.37 months. We determine that by taking the $20,000 gift, dividing that by the current divisor, and we determine that Roger will need to privately pay for his own care for 1.36 months. The solutions to deal with previous gifts: first, we can accept what the penalty period is. The second option would be to return the gift. And then a third option, if it's a viable strategy in your state, is to do a promissory note in order to cure the $20,000 previous gift that was made. Option number one is to accept the penalty period of 1.36 months. If we don't deal with or cure the previous gifts of $20,000, instead of Roger qualifying for Medicaid as of October 1st, Roger is going to be responsible to privately pay for the month of October and then part of November as a result of his 1.36 month penalty period. Instead of Medicaid starting to pay October 1st, they're going to start paying November 10th, because that is the same, that equals the 1.36 month penalty period. If we consider where the funds are going to come from to privately pay for the 1.36 month penalty period, it's most likely either going to come from Nancy's annuity payments of $4,500 per month, or we can look to the community spouse resource allowance, or the amount that Nancy is going to keep at $137,400. With option number 1, if we just accept the penalty period of 1.36 months, Roger and Nancy's annuity plan is going to remain the same. Medicaid eligibility is going to be delayed until November 10th of this year, and the private pay amount is likely going to come from either the annuity payments of $4,500 or from her CESRA amount of $137,400. If we recall that Roger's nursing home cost was around $10,000 per month, he had monthly income of $2,000. His shortfall during the private pay period is going to be $8,000 per month. So if we consider Nancy is going to have a community spouse resource allowance of $137,400, we subtract out the private pay period, it's going to cost the family around $13,600 to be able to privately pay for the 1.36 month penalty period. And after that is paid from the $137,000 that Nancy is going to keep, the amount that Nancy has remaining as cash assets after that private pay period is over with is $123,800. And she's also going to be receiving the annuity payments of $4,500, so she could use some of that to offset the $13,600 that is necessary to privately pay during that time frame. The advantages of and disadvantages of option number 1, accepting the penalty, is that it's a simple strategy where we're only having to use one planning tool, the Medicaid compliant annuity. Almost all states recognize the Medicaid compliant annuity when we're talking about planning for married couples. And Roger is going to become eligible for Medicaid in November. This is 1 month longer than what we were originally anticipating as a result of the $20,000 transfers, but it's still a pretty good plan as far as we have a short penalty period, and as of November 10th, Medicaid is going to start paying for Nancy's care after that private pay period is over. The potential disadvantages of this type of plan is that obviously we're not obtaining immediate Medicaid eligibility. As of October 1st, it's going to be delayed to November 10th. And then the private pay costs are going to either need to come from the annuity payments or from the CESRA amount that Nancy is going to keep if we decide to accept the penalty period of the $20,000 gifts that have been made. Another consideration when we are looking at just accepting the penalty period is to consider what the potential penalty period is or how much the previous gifts are. In our example, the resulting penalty period was only going to be 1.36 months. So using the annuity payments or the CESRA amount to be able to privately pay for the 1.36 month penalty likely is not going to be that big of a deal. But if we have previous gifts of, say, $200,000, which is going to result in a much longer private pay period, the family could consider purchasing 2 annuities, one annuity that's owned by Roger to cover the private pay period of 13.63 months in this case by dividing the 200,000 by Pennsylvania's divisor of 14,676. And that's how we determine the 13.63 month penalty. And then the other annuity would be owned by Nancy, and that would be purchased with the overage amount that the couple still has to spend down to get down to the $137,400. This is a chart showing you that if we did do 2 separate annuities, Roger would own one of the annuities that would be structured for 14 months to cover the penalty period associated with making a $200,000 previous gift, so that the annuity is providing around $79.50 per month to Roger. His shortfall on a monthly basis was $8,000, so we're still below what his shortfall is when we're generating the amount of income necessary. And then the other $150,600 is going to be used to purchase an annuity for Nancy, and that's going to bring the couple to the $260,600 that they needed to spend down. And Nancy could keep her annuity paying out for 60 months, and that's going to generate around $2,600 a month of income to Nancy, in addition to her Social Security income. So by purchasing two annuities, one for Roger to cover the penalty period and one for Nancy with the overage amount, we're not relying on Nancy each month to use her annuity payments or use the CESRA amount to cover the private pay period. We've earmarked the $110,000 to be used to pay for Roger's private pay period, and then Medicaid would start paying in month 14 in this case. The second option is to return the gift in order to avoid the penalty period. So in order to avoid the 1.36 month penalty period, the $20,000 could be returned to Nancy. If the gift is fully returned or cured for Medicaid planning purposes, a private pay period or a penalty period will no longer exist. The annuity amount will increase by $20,000 if the $20,000 is returned to Nancy in order for Roger to be immediately eligible for Medicaid. The original annuity amount will increase based on the previous gifts being returned. So if you recall, the original amount of assets that the couple had was $400,000. If we add back in the returned gift of $20,000 and then subtract out the total exempt or protected assets of $139,400, the annuity amount in this case is going to increase to $280,600. You'll see that we still structured the annuity over a 5-year period or a 60-month period. By putting $280,600 into the annuity for Nancy, and by purchasing the annuity in September, the Medicaid compliant annuity is going to make payments back to Nancy immediately of $48.50 per month, so that the total payout is slightly greater than the amount that is invested into the contract. But Nancy is still going to be the annuity owner, the annuitant, and the payee of this larger annuity policy. By curing or returning the full $20,000 and increasing the annuity amount, Roger is going to be immediately eligible for Medicaid as of October 1st without any kind of private pay period like we originally talked about in option number 1. A caution: if the full gift amount of $20,000 cannot be returned to Roger and Nancy before the annuity purchase or before the Medicaid application is made, and only a portion of the gift is returned, you'll want to make sure that your state recognizes partial cures in order to reduce the penalty period. Some states are not going to acknowledge a partial cure. They'll want the full $20,000 to be returned in order for the penalty period to be eliminated or to reduce a penalty period. So if you're not sure how your state handles partial cures, or if they require full cures of previous gifts, you can reach out to us either by phone or email, and we can help you to figure that out for your state. The advantages of option number 2 is that we're still using a simple strategy of purchasing a Medicaid compliant annuity for the community spouse. Like we talked about with option number 1, almost all states recognize the Medicaid compliant annuity for the community spouse. And Roger in option number 2 is going to be immediately eligible for Medicaid without any kind of private pay period. The potential disadvantages are going to be if the $20,000 cannot be returned or cured. This is going to depend on when the gifts were made and who they were made to. Sometimes it's not an option to be able to return gifts or transfers that were previously made. And so if the gifts cannot be returned, then the penalty period of 1.36 months is going to remain, and the couple is going to have to privately pay for the 1.36 month penalty period. The final option is option number 3, and that's to use a promissory note. Assuming that Roger and Nancy want to avoid the 1.36 month divestment penalty period or the private pay period, and they want to immediately qualify for Medicaid benefits as of October 1st, the $20,000 in gifts could be recharacterized as a loan or a promissory note. The language that must be contained in a promissory note for Medicaid qualification purposes are very similar to the language that must be contained within a Medicaid compliant annuity. It must have an actuarially sound repayment period, must make equal payments with no deferral or balloon payments. It must prohibit cancellation on death. And in order to be non-countable, it also must be irrevocable and non-assignable, which is almost identical language to what language must be contained within a Medicaid compliant annuity. If we look at how we would structure the promissory note or the loan could be structured over Nancy's life expectancy of 157 months or a shorter period of time, depending on how easily it is for that $20,000 to be repaid on a monthly basis. If we were to structure the note over Nancy's full life expectancy of 157 months, then the note is going to have to pay around $130 per month, and the payments are going to go directly to Nancy as the community spouse. And as a result of purchasing the annuity as well as recharacterizing the $20,000 gift as a promissory note, Roger is going to be immediately eligible for Medicaid as of October 1st. The annuity amount is going to remain exactly the same as our no gifting example, where $260,600 is used to purchase the annuity over a 60-month period, generating $4,500 a month for Nancy. The impact of doing the annuity as well as the promissory note, Roger's monthly income is going to remain at $2,000 from Social Security. And then when we consider the promissory note payment as well as the annuity payment to Nancy, her monthly income is going to increase from $5,500 up to $5,630 per month, which still is going to exceed her monthly maintenance needs allowance of $3,435 per month. Roger's monthly copay is going to remain at $1,950 when we consider his income at $2,000 less his personal needs allowance at $50, so that his copay is $1,950. Medicaid eligibility is still going to commence as of October 1st of this year. When we look at Nancy's monthly income, we are going to consider her Social Security income of $1,000 plus the annuity payment at $4,500. And then also we are going to add in the promissory note payment at $130 per month, so that her total income is $5,630, which, as we talked about, exceeds her MIMNA of $3,435. She's not going to receive any of Roger's monthly income, so his copay is going to be $1,950, or the $2,000 less his $50 personal needs allowance. One caution is that many states do not recognize promissory notes as a planning tool. So you would want to make sure that your state does consider a promissory note to be a strategy that will eliminate a previous gift or a transfer by recharacterizing that $20,000 as a loan or as a note. The advantages of option number 3 is that Roger was immediately eligible for Medicaid without any kind of private pay or penalty period. Almost all states recognize the annuity planning, and the promissory note can be structured with payments that are affordable for the giftee to pay back. So like we talked about, if we were to structure that $20,000 over 157 months, then that's making the payments only $130 per month that the giftee would need to be paying back on a monthly basis. The disadvantages of the promissory note is that this may not be an option if promissory notes are not a permitted strategy in your state. And then it's a little bit more complex as far as planning goes to do both the annuity as well as a promissory note. So it's just a little bit more convoluted if we're talking about different planning strategies that a family would need to be okay with employing in order for immediate Medicaid eligibility to occur. Some of the factors to consider when determining which option to choose: we want to consider the amount of previous gifts. If we're talking about a $200,000 previous gift or $20,000, we would want to determine how long the penalty period is, and does the family have enough of a spend down amount to be able to afford to privately pay during that time frame. So if we're talking about a private pay period of 13 months, this is going to be a lot more expensive than a private pay period of 1.36 months. We also have to consider whether the gifts or the previous transfers are curable, or if they can be returned to the parent in order to apply for Medicaid and achieve immediate Medicaid eligibility. Finally, we would want to consider, does your state recognize each strategy as a planning technique? So if your state does not recognize promissory notes, then obviously we can't do a promissory note to cure a previous gift or a transfer. We want to consider the health of both spouses. If we don't anticipate the Medicaid applicant living through a private pay period, then it may be better to just use the remaining assets to privately pay during the time that they're alive, as opposed to doing a whole bunch of complex planning and then they don't live through what the private pay period would be. And then also we would need to consider the amount of resources that the couple owns in order to privately pay. So do they have enough money to cover the private pay period resulting from the previous gifts? And now I will take any questions that people have regarding the content in the slides. There's a question about slide number 39. It says, I understand why Roger's annuity choice was 14 months, but why did you select 60 months for Nancy on the second annuity? Could Nancy have selected a shorter term? And if so, how short? Yeah, so we could have done a shorter annuity than 60 months for Nancy. The shortest annuity term that we're able to offer is a 2-month contract. I wouldn't do a 2-month annuity with 150,600, but if we wanted the annuity term to match Roger's annuity time frame, we could do another 14-month annuity. It's just going to accelerate how quickly the 150,600 is returned to the community spouse, but we can absolutely do a shorter annuity than 60 months. I was just illustrating if we kept the annuity the same as what we originally did for Nancy at 60 months, how that would affect the payout. There is a question about for the promissory note, does the party who is paying the amount back or receiving the amount need to prove that the payments are being made in accordance to the rules? The answer would be yes. You would actually have to have the person that is responsible for paying the loan back, proving that they are actually paying the $130 or whatever the amount is agreed upon within the note, that they are actually making payments back to the community spouse. So that is considered to be their income. Okay, and then there's other state specific questions that I have on here that I can reach out to you directly to answer. I'm not seeing any other ones that apply to the actual presentation. I'll reach out to others individually to answer those questions, but I want to thank everybody for taking the time to join me today for today's webinar. If you think of questions after, feel free to reach out by phone using the phone number on the screen or by email. My email address is amber@ashbur.com. And if, there's another question that just came in. Somebody is asking about how to determine how short you can do a community spouse annuity for, as far as the amount of income that's being generated for the community spouse. I like to keep the payments from the annuity payable to the community spouse comparable to what the cost of care is in that state. So if the cost of care is $15,000, I would feel okay with doing a $15,000 per month payment on the annuity in the event that the community spouse would require care themselves. So if you take the $260,000 and you were looking at generating $15,000 per month, then the annuity would be structured over an 18-month period. But if you start generating $50,000 and $100,000 a month of income, that is likely going to raise red flags with the Medicaid office and potentially be considered abusive. So I like to keep the payments reasonable based on what the cost of care is in that state. Okay, there was another question, but it was something that they said to disregard. So thank you everybody for joining me for today's webinar, and please join us for October's webinar. We're going to be talking about individual clients that have made previous gifts. And if you have any questions, like I said, feel free to reach out to us. Thank you and take care.